my name is Dana. I'm calling from the Court of Appeal, and we're going to be speaking to your application this afternoon.
My applications?
Yes, that's right, applications. That's correct. We have Miss Micklejohn on the other line. I'm just going to patch the two of you together on the conference call, okay?
Okay.
Okay. Mr. Richardson, can you hear me?
Yes, I can hear you.
Thank you. Miss Micklejohn, you can hear me as well?
I can.
The chamber judge this afternoon is Mr. Justice Kalmakoff, and it'll be just one moment.
Okay.
Good afternoon. We have the matter of Dale Richardson and Kimberly Richardson. And Mr. Richardson, I understand you're representing yourself.
Hold on a second. You missed somebody on there. It's a matter of Richardson versus Court of Queen's Bench and Richardson.
Excuse me?
Pardon? Pardon me?
Yeah, let me back up here. Just give me 1 second, okay?
Sure.
Okay. Where are the applications? Okay. Sorry, Mr. Richardson, thank you. I'm just making sure we have all the documents here in the court. There was one that was misplaced, but it's just getting that right now. So yes, it is styled as Richardson versus Richardson and Court of Queen's Bench.
Actually,
so, Mr. Richardson, you're representing yourself, as I understand it?
Yes, let me clarify again. It's filed as Richardson v. Court of Queen's Bench and then Richardson, because the Court of Queen's Bench is the primary respondent, and it's clear in both of them. Richardson is only added on because of the incidental issues that arise from it that concern my wife, Kimberly Richardson. So
okay,
yes. So let's get that clarified.
Okay, thank you. I understand your position then. Ms. Micklejohn, you're appearing for Kimberly Richardson.
That's correct.
And so who's appearing for the Court of Queen's Bench for Saskatchewan?
There's nobody appearing for them, as I understand.
Okay, so then they're unrepresented.
Correct.
So they didn't show any care to appear in court when they were properly served, and didn't show any regard for the or any respect for the court or the due process of law, even though this was to be an ex parte motion.
Ex parte, Mr. Richardson, doesn't ex parte mean that there's nobody appearing for the respondent?
Yes, but I was instructed to serve the motion, which means it's not ex parte. In addition, I have... Okay, hear me out.
There's nobody appearing for the Court of Queen's Bench, as I understand.
Yes. And I do have something that I would like to get out of the way first, because this needs to be clarified before we go any further. I am making both of these motions under my Article 13 right of the Torture Convention. And I've been tortured. And this is my right to be heard. And it cannot be infringed upon. And secondly, there has been a lot of Masonic interference behind this. And today, a declaration went out to the Masons, which was in which the words of the declaration was, "Many, many tekel upharsin," which comes from the Bible, and it means God has numbered your kingdom and finished it. Thou art weighed in the balances and found wanting, and thy kingdom has been given to the Medes and the Persians. And it also furthermore said that the Masons have been judged for the murder of the innocent, for the shedding of the blood of the saints, and for mercilessly persecuting those who follow Christ. Judgment will be swift. And for them to run, the King of the North is coming for you. Now that that declaration has gotten out of the way, the next question is for you, Your Honor. Do you have any affiliation with the Freemasons or any type of secret society?
Mr. Richardson, I have no such affiliation.
I'm going to caution you, Judge. If you lie, God will judge you swiftly.
Mr. Richardson, what you have before me are two applications seeking...
Did you hear what I said?
Yes, I think you should address the merits of those applications.
Acknowledge what I said, Your Honor.
The relief that you're seeking.
Your Honor, please acknowledge what I said.
Mr. Richardson, I'm not going to listen to threats. So
I'm not threatening you. Read the Bible, Your Honor. Revelation talks about God punishing the impenitent and the wicked and those who torture and murder the innocent and his children. That's not a threat. This is something that's based on the Bible. And are you going to say that my Christian faith is threatening?
I'm not going to say that your Christian faith is threatening.
Well, it is my Christian faith. Because the writings of Ellen G. White, which are quoted in these, talks about the Masons and how they will not receive the seal of God. So I'm quoting things that are based on my Christian beliefs. And it's not a threat. It is prophecy.
Your beliefs, Mr. Richardson, that's fine. Thank you.
Okay, so please do not address them as threats.
Well, when you're saying God's going to strike me down, I'm not sure how...
I didn't say that. I said God will judge you.
Oh, okay. Well, thank you. I'm comfortable with that. Now, you have before me motions for writ of certiorari, motion for writ of mandamus and prohibition.
Yes.
And,
let's look at the writ for the mandamus first.
Okay.
Because, for one, counsel made some arguments. And first of all, where's she getting the money to appear? Because the last time I had a motion with J.A. Caldwell in this court, it was cost prohibitive for her to appear, and she only wrote a letter. So I find it quite odd that now mysteriously money has come to appear when I've named certain parties in this motion, namely the rogue agents of the credit union who were the ones who benefited the most from my divorce proceedings. This I find quite interesting, and how it was cost prohibitive before, but it's not now. Where'd the money come from for her to appear? And that's a valid question. Because if it was cost prohibitive before, why now? Where's the money coming from?
I'm not sure. You want me to answer that? I don't know. That's not really my concern.
Yeah, she's sworn that it was on the financial position and that there was no funds. So, what was that swearing in a lie?
I'm not sure what bearing that has on the relief you're seeking.
It has a bearing on why is counsel representing when there was sworn in that there was no No, it was cost prohibitive. It was cost prohibitive previously.
Yes, I don't know how that's relevant, so maybe move on to your next point, please.
What do you mean you don't know how it was relevant?
Move on to your next point, please.
She swore her financial statement.
I understand, yes, Mr. Richardson, I understand your position on that.
Oh, okay, but it's a valid question. It is a valid question, especially with who is named inside of this. Where's the money coming from? It is absolutely integral, because you look at the beginning on the introduction of this, and it names certain parties, and it demonstrates terrorist activity. If she's getting indemnity from ICU, it is a crime.
Well, I don't see any evidence of that. So,
how is there going to be any evidence if somebody doesn't determine where the funds came from? Because before it was cost prohibitive, but now it's not, and her income is sworn in. So this is an issue. In addition, since Mrs. Meiklejohn is implicated in this, it is self-serving for her to come. So there needs to be, what's the motivation? Because it's apparent from this document and from the evidence that is being supplied. And actually, let's go through some of that evidence. Let me get to the page here. Yes, on from Exhibit A, page 366A of the documentation, and I guess it would also be page 365A, where page 364, where she said she received a call from the Court of Queen's Bench to provide a draft order. And this was on July 22nd, 2020, on a first appearance. And then when you look at the orders that were there on that draft order, they're absolutely outrageous. They're the worst of all of the final orders that she asked for. I mean, like, who would ask for such a severe breach of a person's constitutional rights to take such final orders on an interim order? That's not even reasonable. The only way somebody would do that is if they knew that I wasn't going to appear in court, because that's not even within the realm of the scope of reason. No reasonable person could conclude that was reasonable to ask for on a first appearance with no evidence. You see, the problem that I'm running into, Judge, is that I'm producing ridiculous amounts of evidence, and the other parties are producing none. They don't even appear. And
Richardson, George, just to come back to that point, though, it's not unusual for when lawyers are making an application in the Court of Queen's Bench to provide a draft order with their application.
A draft order like that one. Let's read what the draft order says. Let's just read that out loud. Let's see. Okay, they got the interim custody. The primary residence should be with that. Let's go down to the prohibition from the consumption of alcohol and or non-prescription drugs while the child is in the care or in his presence, and that the child shall remain in Saskatchewan. First of all, let's talk about the drugs. What evidence was provided? Because I said so? That somebody is on drugs? So I should just take that and put that order there because I said so? That doesn't fly. The burden of proof is them to prove that that's the issue. And there was no proof that there was the issue. And then, let's see, look at this. That the child born on February 9th, number 7, shall not be left in the care of Keisha Faith Nyasha Richardson with no evidence again, just because she said so. And the parties that were attempting to enter the court that day, they were prevented from an officer of the court, a sheriff. If we turn to page, let's see, there's page 369A. You can see the little box that points out to the sheriff, the officer of the Court of Queen's Bench, participating in the judicial interference. Prevented it. And there was no mention of that in the motion. There are not motions, sorry, in the fiats. None. There was also the transcript of the conversation where the same sheriff was talking to Mr. Cannon. And curiously, during that time, the phone did not ring for either of the phones, one for the corporate matter, for DSR Karras Consulting Incorporated, nor for the personal phone, which Mr. Cannon had possession of. And they didn't ring in the videos, and there's no transcript evidence of the phone ringing. That's quite interesting when a court supposedly is supposed to call someone, which the officer clearly said, but no phones rang. That's very curious. Okay? They didn't even call. And they make these orders. That this how do they explain that? This is criminal. And then on top of that, they leave no way to go back and to deal with this so-called interim orders that actually J.A. Caldwell identified them correctly as final orders about the sale of the house and giving possession of the contents of the house. And you see, Justice Elson, he's a Superior Court judge, and he has actually no excuse for this. He understands the distinct natural person, Section 15, subsection 1 of the Canada Business Corporations Act. He was presiding over both matters. He knew what he was doing when he issued the order to give possession, knowing that the Register Office of a federal corporation that was seeking remedy against the Court of Queen's Bench for Saskatchewan was in the same place as the family court meeting. There's a problem with that. He had intent and knowledge, prior knowledge. And you know what that screams, Judge? It screams intent to punish. Because the only thing that was mentioned that was of any consequence, because some of them were protection orders for the corporation, but the only thing that was mentioned of significance was an order to investigate the Innovation Credit Union, the rogue agents of Innovation Credit Union that were in breach of contract. Actually, let's turn to that on page 240, the non-disclosure agreement. And let's, 241. Let's look at Article 7, which says, any threatened or actual breach of this agreement will cause the provider immediate and irreparable harm, and the provider shall be entitled to seek and obtain injunctive relief for threatened or actual breach of this agreement, in addition to any other remedies available at law or equity. And this was a legally binding contract. And we do have evidence of a breach, multiple breaches of contract. And I'll point you to another clause here before we move forward. It speaks about number 11. This agreement shall be governed and interpreted by the laws applicable in the province of Saskatchewan. All legal proceedings pertaining to this agreement shall be taken before the courts of Saskatchewan. No party shall seek to enforce an order that has its origin in any other courts than the courts of Saskatchewan. So, let's go to the email chain just so that we have that pointed out, so that we can reference that correctly. Just give me a moment here, because I'm dealing with a 5-volume set and I'm flipping through the pages. Just give me a moment here. Oh yes, we'll look at this here starting on page 732A. And through there is an email chain discussing the activities of myself and the corporation whom I represent, and restricting access to my wife, which is quite unusual for them to be getting involved in the affairs of a married couple. It's unprofessional. But let me point you to page 738, where it speaks about speaking to Constable Karchi, and this is from Ian MacArthur from the North Battleford RCMP, and saying that she confirmed that my activities are known to the RCMP. And what activities are they talking about? Talking about the mismanagement of the COVID emergency, as outlined in my professional report that I put out, because I'm a mechanical engineering technologist, and actually currently in my degree program, I'm actually doing research on said mismanagement of the COVID emergency, which is now making me even more qualified to speak on the subject. But I informed them of the risk to the lives of people because of the misrepresentation and the severe financial loss that it would cost to members of the credit union and members in the community as a whole, and the risk to life itself because of guidelines that don't follow proper engineering practice. They're poor engineering practice. This were part of the secrets that were contained in the agreement. There was no such authorization for them to discuss. They did not sign any agreement. They discussed it with another party. That is a clear breach of contract. That put them in violation of that contract, owing to the corporation in the millions of dollars, because it's irreparable harm. And it was a lawful contract. The Court of Queen's Bench with that contract had an obligation to investigate. When that was realized, this is why this was done. They were shielding the money. Who benefits the most from all of this? It is not my wife, because counsel for my wife has been deceiving my wife. Because if my wife understood that the corporation whom I represent was in a contractual relationship that was of significant financial value with her employer, she would have never done that. She might have tried to take the money, but she would never pay for a lawyer for someone else to take her money. Because she knows full well, regardless of the state of our relationship, that I will look after our child, and I have been, and I will not screw over my wife. So nobody is going to go and screw themselves over and pay money to do it. So she is being deceived, and it's clear. And the benefit to them, it is substantial. And this is where the Court of Queen's Bench comes in, because every time that it comes down to trying to deal with Elson's orders, they try to hide it. Everybody has done it. Crooks did it. No other judge wanted to do it. And there is no other remedy for me, because I tried before this court at J.A. Caldwell to get that motion to extend. And when I talked to him and I told him about the Section 7 violations to my liberty and to the terrorist activity that falls under the definition of terrorism, because any disruption to an essential service is terrorist activity, and the violations of the Torture Convention, because the taking of a child without lawful cause, even with lawful cause, causes great duress, and there was no lawful cause. Because we look at where this, let's actually go and examine that as we talk about this. We're going to go to, yes, this is something that Zuck had before him as well. And the fact that the counsel was making that because Zuck didn't have it before him, that it shouldn't be included. No, Zuck used his position to shield terrorists and torture, and he should get no such benefit or protection from the law because he abused his position. Now let's look at this. Page 250, A, on Appendix T, the kidnapping of Karis. Dale, I've spoken to my lawyer this morning, and I've been advised to let you know that at this time, you will not be given access to Karis. And this is also to advise you that you are no longer permitted on my parents' property, and that we've been advised to contact the RCMP if you come on their land. That's breaking the law. Is that lawful for her to do that, Your Honor?
It depends.
Is that lawful?
It may be, it may not be.
Under Saskatchewan law, does that permit for one parent to just arbitrarily take the child without going through due process?
There are circumstances where it may be lawful, circumstances where it may not be.
They don't have any lawful circumstances because all they keep saying is an email that they cannot determine who sent the email. The RCMP conducted an investigation and they couldn't determine anything. So what do they think that they know more than the RCMP? And furthermore, what the contents of the email has stated do not demonstrate that there are any threats to the safety of the child in any way, shape, or form.
Okay, but that's a matter for your appeal, right, Mr. Richardson? I mean, I appreciate
that. Okay, Your Honor, what circumstances permit someone taking the child?
All right, I'm not here to give you legal advice, but what I'm saying is...
No, I'm not asking legal advice. I'm asking you as a judge. You said under certain circumstances that's permitted, and I'm saying right. What circumstances are those? And I'm asking you a question. I have a right to know.
If a person feels their child is in danger, they may have a right to withhold that child from the other parent.
You know what? I'm going to tell you straight out, because I talked about... she didn't have any right. It was imagined. And they still haven't produced that right. Because
I appreciate that.
Wait, I'm not done. I'm bringing my case. I've presented 1,800 pages in this petition to Parliament, which, I might add, has gone to the Committee Against Torture, and they've received it, and has gone to the International Criminal Court, to the Office of the Prosecutor, because I'm quite frankly tired in the way of this court has had no regard for the Torture Convention, no regard for the torture of an infant child who is being punished to punish me for speaking out the mismanagement of the COVID emergency. And oh yes, I do have my witness that I'm going to call to talk about the mental health state of mind that was also present and arrested and unlawfully arrested and tortured by the RCMP. And I'm going to call Mrs. Derry to give some evidence about my mental state leading up to the unlawful, arbitrary, and unconstitutional arrest and judicial interference that was also perpetrated by the Court of Queen's Bench for Saskatchewan.
Yes, hello. My name is Keisha Derry. I have been addressed as Keisha Faith Miasha Richardson in one of those things, I believe, by my stepmother, Kimberly Richardson. But my name is Keisha Richardson. Yes. So my father during that time...
Hold on for a second. What is this?
I put down on the affidavit that I'm calling for oral affidavit evidence from certain...
Well, I'm not permitting that, Mr. Richardson.
You're not permitting that. Under the Torture Convention, right. I can bring witnesses. So you're telling me... You're telling me that you're going to violate the Torture Convention. Is that what you're telling me?
This is not a hearing under the Torture Convention.
I am bringing this...
Listen to me. I am not an investigator. I am a judge. And I'm hearing right now your application for a... No, listen. I'm hearing your application for writ of prohibition, writ of mandamus, and writ of certiorari, which, quite frankly, I don't have authority to grant the relief you're seeking as a judge sitting alone in chambers. So unless you can persuade me that I have the authority, which the Court of Appeal Act says I do not have, I'm not sure where we're going with this application.
first of all, who has the authority to grant those? Let me ask you that, number one.
Well, Section 11 of the Court of Appeal Act says the court may grant relief in the nature of prerogative relief.
Oh, yes.
So the court may, in its discretion, exercise original jurisdiction to grant relief in the nature of prerogative writ. And when the Court of Appeal Act refers to the court, that's not a single judge. That's a panel of judges.
So when it's brought in by motion, why was it not set for a panel of judges then?
Because it was put before me in chambers. And is that? I mean, are you?
Hold on a second. Let me refer you to something here. Let me get you here. It is. Let's see. Article 2 of the Torture Convention. Each state party shall take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction. You are part of the judiciary.
Yes, but
are you? Wait. Are you? Wait. You're part of the judiciary, right?
Mr. Richardson, my powers as a judge are limited by statute.
Are you part of the judiciary?
I have powers that the Court of Appeal Act grants me.
Okay, you realize that no exceptional circumstances whatsoever, whether a state of war, threat of war, internal political instability, or any other public emergency may be invoked as a justification of torture, and there is a no defense clause under Article 269.1. And it gives you jurisdiction. It says that you shall take whatever means to prevent torture. Can you prevent acts of torture? This is the question, Your Honor.
Mr. Richardson, the relief you're seeking is
I'm
prerogative.
asking you a
don't
question.
Have authority to grant that.
Listen, whether or not you can grant all of relief is inconsequential, but some of it you definitely can. And I can tell you, the one thing that you can do is to protect me from torture and the people around me. And that is within your power to do. Because if you do not do it, Your Honor, you will be in violation of the Torture Convention.
Okay.
You will be. And you will have to explain at The Hague why you've done that. Because you don't have that authority to not grant that. It is a command. It is a treaty and not subject to the Constitution. And when I'm bringing to you my complaint of torture, which is the foundation and the reason why I'm bringing these things, you still do not have the authority to stop me from bringing someone to corroborate my torture. That in itself, Your Honor, is a violation of the Torture Convention. And you're telling me that you're going to violate the Torture Convention sitting in chambers.
I'm not violating the Torture Convention.
Really? So then why did you stop my witness?
I'm not permitting you to call evidence in that fashion.
But that's the Torture Convention is the reason why I'm asking for this.
I've made my ruling. Move on.
Excuse me? Excuse me. Under what grounds? Under what law? Under what law? Under what?
There is no basis to receive this evidence in this fashion. I'm not going to do it.
Under what law?
Okay, Mr. Richardson, if you don't move on, I'm going to end your submissions, and I'm going to hear from Ms. Michaeljohn.
Excuse me, but I'm asking you the justification. I have a right to know. You're making...
I've given you my justification, Mr. Richardson. I do not believe I have the legal authority to grant the relief you're seeking. Therefore, I'm not going to hear evidence on that point.
You can't grant... Okay, let's look at the relief that I'm seeking. Let's go to that right now. Let me pull this up here. And I might add, oh Lord, I feel sorry for you, Your Honor, because this is very, very, very bad. This is extremely bad. Let's look at this. Okay. Asking for protection from the terrorists and those who are torturing me. You can't grant me that remedy?
I haven't seen anything in your material, Mr. Richardson, that convinces me or persuades me or even makes me think that
can I ask you? Let me stop you.
So, No, I'm not going to.
You're saying that nothing in my material. Are you? First of all, I'm going to say that you right now need to defer this to someone else, because I've also alleged that people in the Court of Queen's Bench for Saskatchewan, the Court of Appeal, have tortured me. You are not a competent authority to determine whether or not I've been tortured or not, because the court that you sitting on the bench for are the ones that have tortured me. That's like asking a woman who is raped to go to a rapist for justice. That's exactly what it is. And you are not in any point, shape, or form to say that you don't see grounds of torture, because you're part of the party that has tortured me, and that is extreme prejudice and bias. Extreme prejudice and bias. You should refer this to someone else. And in fact, it should be referred to Parliament, because they're the only competent authority that can deal with this. Your Honor, you are doing something that is against the law.
Can you point me in the direction of something that says I have the authority to refer it to Parliament?
You can refer. There's a no defense clause. You can make a recommendation to Parliament and say that this is beyond the scope of our authority to deal with, and the only people that can deal with it is the Parliament. You can address them. They appointed you. You could have sent it to the Privy Council and get the Privy Council to refer it to the Cabinet, which will then refer it to the Parliament. You see, they are a competent authority. This court, based on its bias and the way that it's treated other people in this matter, has demonstrated their prejudice. And the fact that what the council has been doing, asking for costs in this, is torturing me. She knows that the Court of Queen's Bench has decimated me financially. And to ask for that in of itself is asking you to use your position to torture me. You see all of this evidence that is there, and you are telling me that with what you see in here, that there is no grounds for this? That is absolutely absurd, and you are sitting on your seat committing perjury. Well, the God of heaven is taking record of this, because no matter what you say, he will judge you as if you understand every sentence of it, because this is not going to happen. You see, you think that within your seat, you have the power to go and do these things. God is going to show you otherwise, because you know what? His word does not say that this is the way things are going to happen. They're using this COVID to destroy Christianity. Now let's go on. Speaking of that,
Richardson?
I'm not done.
Mr. Richardson?
I'm not
Thank you. You are done. I am ending your submissions now. I'm not going to hear anymore. Your language has become extremely abusive towards me. I'm not listening to it anymore.
You're torturing me, Your Honor. You're torturing me. You are torturing me. I'm telling you right now, you are torturing me. You are restricting my ability to speak about my torture. And you are violating my Article 13 rights.
You're not addressing the legal issues that I've raised.
The legal issues are the torture. And you're telling me that you don't see anything in all of these 1,700 pages that demonstrates torture. You're not telling me that the court, the officer of the court that participated in the arrest and did not mention it to the judge, that doesn't say anything. That doesn't seem unusual.
Mr. Richardson, I don't see evidence there that anything that qualifies as torture in my understanding of what the torture convention.
Okay, let's go over what it says. I was strapped to a bed and drugged against my will. And actually, the person that you're preventing from speaking is my next of kin, who can testify that there was no mental health issues when they arrested me. And you are preventing that from happening because she can and has testified under oath that there was nothing wrong with me. And who knows me better than my next of kin? She lived with me, and she was with me every day, all the time. So that makes it very problematic. And this is one of the reasons why they shut it down. Because you are preventing her from substantiating the torture. And this is where the problem lies, Your Honor, because it's critical to demonstrating that. And in restricting that, that is showing extreme prejudice. That is not allowing me to make my complaint of torture, which is the basis of why I'm asking for these things. Because when you substantiate the torture, then they become warranted. But you're not allowing me to do that, which it is in your power to allow that to hear it. You're choosing not to. That's extreme prejudice, Your Honor. Because strapping somebody to a bed and drugging them against their will is not lawful, especially when they have no history of mental health, and the people that are around them consistently that can testify to their mental health, and a doctor who has treated me for 12 years at least has testified in the material that there was no mental health issues. That becomes problematic. And it also becomes problematic when you take into account the fact that I was arrested by defendants in a matter that I was to appear on against them. And now let's actually get to the heart of why that happened. We're going to go and look at this evidence here. Let's go to page 189. Have you gone through all this information, Your Honor?
I've gone through it.
Okay. So based on my professional opinion in this COVID mismanagement report that starts on page 189A and continues on, where I've given my professional opinion as a mechanical engineering technologist about the representation of the mixing factor that was by the Saskatchewan Health Authority. That was the political opinion of myself and the corporation and others around me based on my professional opinion and corroborated by a professional engineer that has a wealth of experience that demonstrates that they left out critical information on a table for a COVID-19 mitigation. And it was a guidance document that they placed out. And it's negligent. Without knowing that mixing factor, it introduces an unknown that is unacceptable for any engineering controls. You can kill people with that, Your Honor. That is criminal negligence. I went to the RCMP and filed a complaint and filed torture complaints. And instead of doing something about it, what do? They arrested me when I took them to court for not doing their duty to protect the lives of the general public. This is a crime. And without a doubt, and I'm telling you on my professional opinion, and it is your responsibility to listen, because I questioned Apex about it, and they didn't respond. They threatened me. And when they got the response, they ran with their tail between their legs because they violated their own laws that govern them. And I can show you that because it's actually in the report on page 223A, the response to the letter that Apex sent to me after I sent them the email that starts on page 220. And then you can see the response to them on page 225. When it was dealing with the lives and the safety of other people. Citizens are at risk in Saskatchewan. Are you telling me that the lives and the safety of the innocent citizens in Saskatchewan are not worth investigating the matter and reviewing this? Because this can kill people It's no longer negligence. It's deliberate, willful intent because they're aware of this. And the conversation that I had with with Chad, which begins from Innovation Credit Union, which is also discussed, was spoken about. It starts on page 292 and goes to 302. Clearly explains to him the threat and the risk. And the risk to the members of the credit union, which I might add I still am, even though they took away closed my accounts because I mentioned this. And the people that were involved in that communication were the ones who did so. Now, this is a severe risk to the health and safety of the citizens of Saskatchewan. And I'm telling you with my professional opinion. And I'm telling you that I'm also doing research on this as well. This threatens the lives and the safety of the innocent people of Saskatchewan. It can destroy businesses if they do not have proper pandemic mitigation. And this could actually enhance the spread of COVID and other deadly pathogens. Now, I'd like to hear your response to my professional opinion, Your Honor.
I'm not sure what response you're looking for, Mr. Richardson.
Well, do you think that the lives and the safety of the residents of Saskatchewan, like elderly and children, should be protected from deliberate negligence that could cause them death?
Well, as I understand your position, these other parties are committing crimes for not taking your advice.
Were any of those people engineers or technologists that didn't take their advice? Because a professional is supposed to listen to the advice of a professional. And I spoke to Apex, and you saw the response that they gave. They didn't address it. And when I talked to them about addressing the issue that may potentially kill people, they never responded again.
So what am I supposed to do about that?
What do you mean? If you know somebody's committing a crime, what are you supposed to do? Ignore it?
I don't see that as a crime, Mr. Richardson.
Okay, I'm going to explain something to you about engineering. And this is the way engineering works. When something goes wrong, the engineer usually goes to jail because they know better. Because when it comes to designing things, you have to err on the side of the caution. You have to over-design when you're dealing with human beings because of the severe threat to life, and you cannot replace a human life. Now, when this happens, and someone who is an engineer or a technologist says that there is a threat to human life and it needs to be addressed, there's an issue. Because anybody who is not even an engineer or technologist can, from looking at this table, because if you look at page 191A, you see the table how it's represented with this by the SHA. There's no mention of the mixing factor. But now let's go over to page 194. And there's a box that's there that tells you what the mixing factor does. And I'll read it for you. It says, the times given assume perfect mixing of the air within the space, i.e. mixing factor equals 1. However, perfect mixing usually does not occur. The mixing factor could be as high as 10 if air distribution is poor. The required time is derived by multiplying the appropriate time from the table by the mixing factor that is determined for the booth or room. The factor and required time should be included in the operating instructions provided by the manufacturer of the booth or enclosure, and these instructions should be followed. So if you have anybody can understand that time on those tables that they provided by the SHA that were on page, page 191, those times could be multiplied by up to 10. So you think that you've got a person there with COVID or something even more deadly that spreads through aerosols, but you don't know what your mixing factor is because it wasn't even mentioned in any of the documents. You think your mixing factor is 1 like the table represents it, but it's actually 5. You look at the chart and you see that it's 69 minutes. So you wait 70 minutes and you put a person in there, but it's actually 5. And you needed 5 times that much. What have you just done? You've just infected someone. You've exposed them to a deadly contagion because an unknown was introduced into this without putting something down as simple as a mixing factor, which is critical in order to use that charge. Now, I'm telling you, because I am a professional and in a position to do so, that this is negligent and it's criminal, because people can get killed if they use this chart as it is, because without knowing and determining the mixing factor, no one can intelligently say for a certainty whether a system can fall within these guidelines that have been put out, because it is missing a critical piece of information that gives context to this information.
Mr. Richardson, I understand your position on that, but as a judge, I don't have the authority to direct that criminal proceedings be initiated against someone.
Listen, Judge, you cannot sit down and see this knowing that people can die and do nothing. That makes you liable. That makes you, you can't sit there. If I see somebody committing a crime and I do nothing, I'm complicit. This is a crime, and I'm telling you it's a crime, and I've explained it to you. How it
I do not have the legal authority to direct that criminal proceedings be instigated against those persons.
I didn't say that criminal proceedings, but there needs to be something done.
Well, what do you want me to make in order that they listen to you? Is that what you're looking for?
There needs to be, first of all, this whole issue. I'm going to sit down and say, the judge, you have, as a judge, have considerable discretion.
No, I don't.
Really?
I have the powers that are granted to me under statute. As a judge of the Court of Appeal, I have powers that are granted to me under statute.
Do you know, you realize I've read the Court of Appeal Act, right? You realize that. And I understand what the powers are granted by the Court of Appeal Act, and I can pull it up right now if you'd like, and we can go over them.
Direct me to the provision that says I have the authority to do what you're asking me to do here.
Oh, Lord. I'm gonna pull up the Court of Appeal Act here. Just give me a moment. You can issue a prerogative writ. And it says, the court may in its discretion exercise original jurisdiction to grant relief in the nature of a prerogative writ. Is that not correct?
It says the court, not a judge.
Well, are you not an agent of the court?
No, when the Court of Appeal refers to the court, it's referring to a panel of judges, not a single judge.
Where does that say that in the Act?
Section 20 of the Act. And Section 2 of the Act says judge means a judge of the court. Court means the Court of Appeal. Now, Section 20 for a single judge sitting in chambers.
Yes, that says they may hear and dispose of an application or motion that is incidental to a pure appeal or matter in the courts and that does not involve the decision of the appeal on the merits, which does grant you the power to hear this and grant it.
All right, I understand your position on that.
Well, that's what it says. What does the plain reading say? We're both reading English here, right? Because the English is plain.
Yes, but is this, I mean, this isn't something that's incidental to an appeal.
Excuse me? It's not? The torture from the Court of Queen's Bench is not incidental to the appeal when I've alleged that they've tortured me and that they've violated numerous things? This is not incidental? Excuse me? I don't see how you could even begin to say that's not even remotely reasonable. No reasonable person can conclude that.
I understand your argument, Mr.
It's not understanding the argument. It's not reasonable. It's not even within the realm of you'd have to take leave of your senses to do that. It's not even remotely, it doesn't make sense. I was strapped to a bed and drugged against my will, Your Honor, because of this. On the day I was supposed to appear in court. On the day I was supposed to be in court, in front of the court, and the officer of the court participated in it. And they made no mention in any of the fiats. The phone didn't ring when they were supposedly, the officer said that there was going to be a phone call. You're telling me that seems normal to you? Is that a regular occurrence, Your Honor? Is that a normal occurrence? I'm asking you a question.
It doesn't sound like a normal occurrence, Mr. Richardson. I'll
agree
with you on that.
If it's not a normal occurrence, does that not warrant investigation? When the very respondents in the matter are the ones that strapped me to the bed and drugged me against my will. The very respondents.
Well, that's a matter for your appeal, Mr. Richardson.
It's a matter for my appeal, really. But the thing is that I can't get any relief from Elson's orders because they've ensured that was it. And since there was no other way to get relief from that, it is warranted for this. It is absolutely warranted. Because you can't tell me any other way I can get relief of Elson's orders. I can't. And he gave final orders in an interim order. He gave final orders. Is that a standard practice on a first appearance to just give away everything and give away the possessions of another person and then forcibly transfer an Indigenous woman from her ancestral homeland without lawful cause? And then to steal the possessions of a corporation and hand them over in a family matter? Does that seem normal, Your Honor?
Mr. Richardson, I understand you don't think your matter was dealt with properly.
Oh, not don't think. What does the evidence say, Your Honor? What does the evidence say?
Mr. Richardson, I'm not here to argue with you, all right? I'm here to hear your submissions.
Are you going to endorse Elson's order as an agent of the court?
His order is not before me. His order is not under appeal.
Excuse me?
You were denied leave to appeal it. Did not Justice Zuck say that he's going to uphold his orders? Did he not say that in the fiat? But okay, then you have an appeal filed against Justice Zuck's order, correct?
First of all, I can't touch Elson's orders, and asking for the review is for something when you have no other recourse. And I have no other recourse for Elson's orders. They gave final orders that caused me irreparable harm, and he tortured me. He took away everything that I have without due process of law. That is unconstitutional. Torture is unacceptable. Taking my child, and then when I'm worried about being strapped to a bed and drugged against my will because I spoke out about the mismanagement of the COVID emergency, which can take the lives of people, they want to use that. And either you get tortured and run the risk of being tortured and murdered, because when they drugged me against my will, they could have killed me. let me point you to this here, as I when I go to say this. Let me get to the page here. Page 346. And let's look at the date of that. That's September 4th, 2020. It says, I've seen this patient since 2008. During this period, there was never a time that he displayed any evidence of any significant mental health issues. This was a doctor that treated me. He was the one that discovered my heart condition. And then oh yes, since we're on the mental health board, let's examine what Miss Tanya Browerny did, because this is absolutely relevant. Let me get the book for that. Okay, let's look at the what she said there. Ryder had attempted to get his attention when he initially opened the door. However, Dale did not give anybody the opportunity to speak. Ryder followed up with J. Engelke to move forward with the mental health one. He advised to move forward. Let's go back to 327. There's a transcript of this. Is there any female voice speaking on page 327? This is a transcript. Do you see any female voice? Notified, it's only Dale and Ken Startup is all I see. Do you see that? Are you on page 327, Your Honor?
I'm looking at it.
Do you see anywhere that it mentions a woman speaking?
The transcript doesn't, no.
Nope. Let's look at the pictures of Tanya Browerny. She's got the boxes over her head. She's got her hands in her pocket. All the times, and in some cases, she's got her head down. Is that the way you get somebody's attention? Your Honor?
Okay, I understand. So
Wait.
You're saying that doesn't demonstrate that she's trying to get your attention.
Does that how you get somebody's attention?
You're saying that doesn't demonstrate that.
Does it look like she's trying to get someone's attention?
I'm not sure what it looks like.
It doesn't look like she's getting attention. You know it.
I understand your position.
Now, let's go over to the Mental Health Act. Where it says in section 18, subsection B, well, let's read sub 18. Subject to subsection 2 and the regulations, any person may be conveyed to a place where he or she may be examined by a physician who is admitting privileges to a mental health center. If that person is, you have to say that the doctor has to say that they're suffering from a mental disorder, and B, Title B, refuses to submit to the examination meant in Clause A. Okay. Was there any in that transcript, was there any mention to submit to a medical examination?
I don't see that, but I don't know if that captures the entire
that
exchange or not.
Captured the it's in the transcript. Have they provided any evidence to the contrary? Have they provided any evidence, Your Honor?
I don't know, Mr. Richardson. I mean, the validity of the mental health warrant. This isn't an appeal from the mental health warrant.
Yes, but it's tied to this. It's tied. Listen, Your Honor. If I stepped foot in that court, those orders would have never been made. Elson could have never made those orders if I was inside of the court. This is absolutely critical to the issue of those orders, and they affected them, and they're tied to it. So yes, it is absolutely relevant. The fact that I was taken and abducted in front of the courthouse to prevent me from entering the court is absolutely relevant, and this tells you because there's no examination offered. There's no mental health warrant. There's no mental health warrant. Everything else falls apart like a house of cards on a windy day. There's also another, and then also, since she also violated Section 19 because I didn't refuse to submit because I was never offered an examination, and that also in itself poses a problem because she also falsely swore that I did, which that means she lied. So with that issue, how do you explain that, Your Honor? Because it's clear from that there was nothing. There was no command to go to submit to the examination. Your Honor, I'm asking a question.
I'm not here to explain the actions of those people, Mr. Richardson. That's not my role.
But I'm saying, without that, and actually it is absolutely relevant, because that's what prevented me from going into the court.
I understand.
No. It's irrelevant because I got arrested entering the court, and the officer of the court assisted in preventing me from entering the court. And he's an officer of the court. That means the court was involved in preventing me from entering the court that day. So it is relevant, and it is extremely tied to this. Because the court, the officer of the court, prevented me from entering the court. This is why we wouldn't have been at this point if there wasn't that judicial interference. Because if I entered the court, would they have been able to strip everything? Would they have been able to put over the matter sine die for the corporation? Would they have been able to take everything from me with me standing there to speak on my behalf? Would they be able to do that, Your Honor?
Would they have the authority to make the orders they made? Yes, they would have the authority, but I can't guess at what would have happened.
Yes, but do you think that they could just do that if I had evidence on my behalf and I had something to say?
There's no point guessing at that, Mr. Richardson.
And that Mrs. Derry was there as well, who could speak as to refute the claims that counsel for the for my wife has presented. It would be highly unlikely. I would also like to make reference to something from a habeas corpus that is CA 3708 that is related to this. And there's
I don't have that before me.
What?
Well, I don't have that file.
An affidavit from July 27th, 2020. I'm going to read something. Yes, it says, this is the affidavit of Robert Cannon, who is an impartial witness. He said, other than washing breaks, showers, and a dentist, Dale Richardson and Keisha Derry have barely left my sight in the past number of weeks up until the arrest due to justifiable concerns relating to recent discrimination. At no point during this time did Dale Richardson deny any form of treatment to himself. That's another witness that's in the habeas corpus that's before this court. And that was also the subject of something in the Court of Queen's Bench. And then he also says in paragraph 2, at no point during the course of our dealings did I believe Dale Richardson to be a threat to himself or to others, and I still do not. And it says see Exhibit 12. Even after they started mentally torturing him and his 18-month-old by unlawfully withholding her from him, he did not demonstrate any violent behavior, even during his unlawful arrest. He did not demonstrate any violent behavior. So, I do not, and he says, furthermore, I do not judge Dale Richardson based on some past record that I cannot see. From the moment I met Dale Richardson and his daughter, Keisha Derry, they have both desired and in many ways sought to help people, and I labored to help them and others. Before being arrested, appeals were made to the United Nations requesting that he, his family, and affiliates become protected persons, and investigations be launched by the United Nations and the International Criminal Court as well as other authorities. As he feared for his life and the lives of those he loved, and he hoped someone would listen. You see, Your Honor, I'm concerned that I would be tortured and murdered. And that is the motivating factor behind this writ of mandamus and prohibition and the certiorari. And I quite frankly, I believe if nothing is done, I will be tortured and killed. Because I believe that these people will do it again because they have nobody to stop them. They've been able to do this to me with impunity, and my life is at risk. And this is what the crux of the matter is. I was also strapped to the bed because of my agreement with portions of the political opinion of the Jesuit-affiliated Carlo Maria Vigano. And they used my divorce as a means to punish me. And it demonstrates that if they strapped me to a bed, that they would have strapped the Archbishop to a bed and done the same thing to him because they hated his political opinion. And I will also add that as a Seventh-day Adventist, no one can sit down and say that I'm sympathetic to Catholic doctrine, because the Seventh-day Adventist Church teaches that the papacy is the little horn spoken of in Daniel 7. With that being said, I believe in religious freedom, and everyone is free to practice whatever religion they so choose, whether I agree with it or not. And I will stand up for the rights of Catholics to practice their religion because their rights are being infringed upon. And I'm not going to stand idly by while people are being abused, no matter what their situation is, because I don't believe in compelling anyone, and I don't believe in force. And the fact of the matter is that there's evidence of torture being laid before it, and the court is using its power to try to take out evidence that was shut out using the power of a judge that is incriminating towards them, and then has the gall to ask the judge to torture me by asking for costs. I'm going to read something else from this. This is on page 473. I'm going to read this here. And this is from the Affidavit of Robert Cannon on page 473. A. While I was waiting outside the door next to the porch, two of the members of the Royal Canadian Mounted Police approached me and started talking with me. One of the members did most of the talking and tried to ask me questions. When I did not answer his personal questions, he said that I did not have to be a robot and that he was just trying to be personable. The member then proceeded to ask me for the corporate phone, which at the time contained the videos of the interactions between the Royal Canadian Mounted Police, DSR Caris Consulting Incorporated, Dale Richardson, Keisha Derry, which allegedly incriminated them. The member proceeded to ask me what I was getting out of helping Dale Richardson and Keisha Derry. The member stated that I could just give him the corporate phone and walk away from all of this. I told the members that if I did in fact have the corporate phone, it would be illegal for me to hand it to them without proper authorization from DSR Caris Consulting Incorporated. The other member told me that he didn't care for that stupid stuff and that I should just give him the corporate phone. The first member then said that I could go. I told him that the corporate car was in the way. Oh, I also have something that I need to pull up here. Just give me a moment. I know there's a lot of information here. This is really more than that should have been heard in a very short period of time. Let me get this here. Just 1 second. I'm pulling this up on my computer. Yes, I also have third-party witnesses. Where is their defense? I'm bringing evidence, and I'm not seeing it coming back from the other way, and I just don't understand how this is the case. How is it that somebody has evidence, and the other people come with no evidence, and it continually gets brought in that way? Just give me a moment here. I'm just pulling up this information. Yes. So again, where is the evidence from the other parties with respect to that? Because does that sound like it was legal, Your Honor?
They haven't filed any evidence in response to your applications that are before me in any event.
Yes. So where is the Queen's Bench to argue their case? Because honestly, Patricia is not the person to argue this mandamus because it really doesn't really apply to her. The command is not for an order of mandamus for Kim, nor her, because it doesn't apply to them. You can't make a decision for mandamus based on what the counsel says. She's irrespective of the proceedings. She can speak to the couple of clauses that relate to her, but asking her to dismiss the mandamus is unwarranted because it doesn't apply to her. The only person that could ask and to speak to that is the Court of Queen's Bench, and they're not represented here. And you have no authority to dismiss that without them doing that, because that is extreme prejudice. And by virtue of any such demonstration of that will show that you shouldn't have been making the decision in the first place. So, again, what should be dismissed is counsel's request to dismiss the mandamus because it doesn't apply to her. It doesn't remotely apply to her. It's not something that you do to an average person. And for her to speak to that is wrong. Yes, that's one.
Well, one of the things you are seeking in terms of relief, Mr. Richardson, is an order removing her as counsel for Kimberly. It does concern her at least to that extent. I think I have to hear.
Yeah, she can speak to that, but she can't ask to dismiss the rest of it because it doesn't apply to her, and that's prejudicial. And that's extreme prejudice, Your Honor. So,
Sorry, is that the end of your submissions then, Mr.
No, I'm
Richardson?
not done. I'm just looking for something on my computer here, sir. I'm not done. Because there is another affidavit that needs to be spoken to. And, oh, jeez. Sorry, bear with me. I have ADHD and everything doesn't always go as well as planned. Oh, just give me a moment. I'm just I'm just getting this thing over. My computer's just going a little slow. Okay. Oh, hold on. I gotta get the right one. I opened the wrong one. There's an affidavit dated February 16th. And just let me get the right one here open so that I can get it here for you. And okay, there should be on there, it should be down on the last portion here. Okay, let me pull this up here. I'm going to try pulling it up a different one. Just bear with me one more minute, please. Just 1 second here. Jeez. Okay. Let's go to the. It should be actually. I should be able to pull it up from the motion itself because I'm having some technical difficulty here. So I'll just rip it straight from the motion. I want to look at the conversation that was with Glenn Baker and Lawrence Littman in the case that was in. It was the case that was in for the immigration case. And it should be in the brief. I believe it's. Do I have it in the brief of Flax and Law? Let me look here. Oh yes. We'll direct you starting on page 8 of the brief of Fact and Law.
Okay.
this is a lawyer who is practicing in the United States, but he also is licensed to practice in Saskatchewan. And he's quite familiar with the laws in Saskatchewan. And you can sit down and see that he talks about that it's in the paragraph that you can see it's marked at 35 minutes. He says that he sees it as a political statement, a political nature, a political statement of the government doing the wrong thing in the regulations and COVID. And he says, so the lawsuit is of a highly public nature, and it threatens in the civil proceeding the RCMP and many members of the Health Authority Board and the Saskatchewan Health Authority, which is a government agency. And then he furthermore says, I have the details of all their actions, but the point as it relates to this respondent is because of her political opinion, she was falsely arrested. She was taken and held in detention, and she has suffered injuries as a result of her arrest. That was at 3636. And then, where she said, this is what she says in 3828 from Keisha FN Derry. It says, in Canada, we have to go to the jurisdiction and file against the jurisdiction that hurt us in the jurisdiction that hurt us. So I would have to file against the RCMP with the RCMP that actually did this unlawful arrest with me. I was pretty terrified to have any further communication with them. I just ran. This is what happened outside of the court. Does that sound like she was scared? Your Honor?
I'll have to look at that more carefully.
Really? That's what she testified in the court. It's on the court transcript. And then they said he asked, why was your father in the hospital in 40, where it says 4010? He asked, why was your father in the hospital? And let's go to the underlined parts. They said that he was arrested under a mental health warrant for refusing mental help and for religious delusions, for a religious belief, and for things that he's going on. I believe also with the corporation, but the stuff they told him specifically in the hospital. And then they watched the video. And then they talk about even Keisha's arrest, where it talks about her being arrested because she said it was a violation of the Saskatchewan public health order. But he says, let's go to 4135. Littman says, right. And it's also discretionary because it taught, and this is what she testified to you. She told him in the tape that it says that I can be here. This is a necessity. I have a mask, and their total disregard for any of our rights or explaining. And maybe I don't know if you can see it here. And then Keisha testifies in 4046. I'm the chief communications officer of the corporation, and that's why I thought it was a necessity to attend the hearing, because I had the complaints launched with my workplace based on the conflict of interest of information that was given about the mismanagement, and I felt that I needed to be aware of what was going on so I could properly communicate for the corporation and to my workplace, the Saskatchewan Health Authority, about the proper procedures that would be necessary going forward. And then Littman goes on furthermore to say, this affidavit explains what happened to her on her arrest and her incarceration and interrogation, which basically corroborates the testimony that she gave to you today. She's like, and it says the underlined portions that are italicized. So I'm not sure what the nature of this lawsuit was, but she did swear an affidavit which sets forth in detail her arrest and what happened to her in the facility, the mental institution that she was isolated in and interrogated by the RCMP for hours, which is pretty unusual for a COVID victim violator, and denied counsel, denied communication, etc., which is highly unusual for any citizen to have to go through, and then also as part of the exhibitor's asylum application, which I might add, counsel did file to the Court of Queen's Bench, which Zuck didn't see was an issue. And then when she talked about this, Littman further goes on to say about the arrest, well, that's not procedure. The procedure, if she's restricting arrest, or is obstructing arrest, which doesn't appear to be They just arrested her as soon as they started arresting her and then him. They claimed it was pursuant to the violation of the court order, which she says there. I didn't violate it. It says I can be here. The procedure would be to take you to the local police department, not the... And then it says they didn't have an arrest warrant, so why are there 6 people at the hearing, which is a civil proceeding? Why are the RCMP and the government there? Well, first of all, I guess it's because they are named or responded in that action and probably not too happy about it. So in the meantime, they have 6 officers there that come and arrest her, and when they arrest her, I don't even know if they arrest her, they detain her. There doesn't appear to be an arrest warrant. They don't take her to the police station where the local police take people. She's taken to a place where she actually works, the health authority hospital, which is composed of 2 sides, the criminally insane criminals, and that's where she's taken. And there's the other side, because she works there out of coincidence, and the other side is for people that basically can't take for your father or mother that has Alzheimer's. So she's taken there and detained and questioned, which has nothing to do with any proper procedure, but it's done by the government, which is the health authority, and it's done by the RCMP, which is an arm of the Canadian government. And he says in 51:18, well, she was tortured in the conduct of her arrest and her activities. And then we'll furthermore go on in 51:21 of Littman, where it's underlined. It says, and then she's held without sunlight for 23 hours a day. She's followed to the bathroom more and more in terms of what she calls abduction. So she's abducted by the RCMP, put in this prison, and treated like she's in isolation or in solitary confinement. Then she makes statements about her consumption of water and lack of food. And we're not talking about a third world country. We're talking about a civilized society. So I submit that her fears of what happened to her are real. And I have a fear that they will torture my daughter again because they tortured her. And then she goes on, he goes, do you know why the judge in 53:15 says, do you know why the RCMP were outside of the courtroom waiting for your father? They told me that they were aware that I would be attending court and that my father would be attending court. They did not give him a warrant at the time of the arrest. They presented one later, but did not have his proper information on it. His birthday was wrong and other things, but the warrant was a mental health warrant. But it was also not a lawful one, in my opinion, because it's currently in the federal court right now, and I believe because he was seeing a counselor, he was trying to conduct his business, he was functioning, exercising, eating well, taking care of his daughter financially, mentally, spiritually, emotionally, doing all that he's supposed to do, keeping up with his ADHD treatments and everything. So he's trying to battle that currently, but they claimed it was for mental health. Does that sound like somebody who is mentally unstable? Does that sound like the description of somebody who's mentally unstable? And also,
that's her description of things, Mr. Richards.
Are you satisfied with my mental health being found normal based on medical opinion and Robert and Keisha's testimony? My next of kin? Your Honor?
Sorry, are you asking me that rhetorically? I'm not sure.
I'm asking you, are you satisfied with my mental health being found normal based on medical opinion and Roberts, an impartial witness, and Keisha, who is my next of kin, their testimony?
Okay. Mr. Richardson, these are things I'm going to have to think about. I'm going to reserve decision here today because you've given me a lot to think about.
I'm not done.
Well,
I'm definitely...
I'm going to give you about 5 more minutes, Mr. Richardson. You've gone on for, this is an hour and 35 minutes already, which is a long time in a chamber's application. So I'm going to give you about 5 more minutes to wrap things up.
You have all of these impartial and professional testimonies as well, and there's nothing to the contrary. And let me just read out here, since we're on there, the definition of terrorist activity. An act or omission in or outside of Canada that is committed in whole or in part for a political, which the mismanagement of the COVID emergency is, religious, which the religious persecution that I've been suffering, saying that my religious beliefs is a mental delusion, and an ideological purpose, which is tied as what the Archbishop calls the Masonic adage, solve e coagula, to build a world without freedom. That ties all three together, in whole or in part, with the intention of intimidating the public, or a segment of the public, with regards to its security or its economic security, or compelling a person, which is me, or an international organization to do or refrain from doing any act, whether the public or the person, government, organization is inside or outside of Canada. And let's look at II. That endangers a person's life. When I was strapped to a bed and drugged with substances that I do not need, that endangered my life. That could have murdered me or destroyed my brain or both, and causes a serious risk to the health and safety of the public or any segment of the public, which in that mixing factor can cause people to die by spreading disease, because it introduces an unknown into this that is criminal. And that is my professional opinion. And Robert's professional opinion of ICU's involvement, and he is an accountant that specializes in managerial systems in CACV 3708. And it must be considered as well. Specifically, without limitation, the fresh adduction of evidence motion. And then, so we know that established that mixing factor causes a serious risk to the health and safety of public or any segment of the public, because you see that mixing factor can be as high as 10. People can unsuspectingly be putting people lives at risk. So that is also one of the clauses. So two of those clauses are being fulfilled in the terrorism. That E causes serious interference with it or serious disruption with an essential service, whether public or private. DSR Terrace Consulting Incorporated is an essential service as it conducts its businesses in HVAC. And what Elson did was order a severe disruption of an essential service when he handed over the entire property, the registered office of a corporation, disrupted it when the RCMP and the court of the officer of the court unlawfully arrested me. That was arrested Keisha. They arrested the officers of a corporation and tortured them and stole the vehicle. It was a severe disruption of an essential services, and it is terrorism under Canadian law. And this must be referred to Parliament, because the Attorney General of Saskatchewan's office is implicated in the foregoing terrorist activity, and within the material, the Attorney General of Canada is also implicated in the foregoing terrorist activity. And because of that reason, it must be given to Parliament, because Parliament is the only one who can remedy this, because the Attorney General of Saskatchewan and the Attorney General of Canada are the ones who order investigations into terrorism, but they're both implicated. The only people who can solve this is Parliament. It must be directed to the Privy Council. Otherwise, that means that if you do not, Your Honor, you are party to the foregoing terrorist activity. There is nothing that you can do. It's clear cut that it's terrorism. DSR was evicted from Saskatchewan because of the NDA, and the agents of Innovation Credit Union are the ones who benefited the most from it. It is undisputed, and it's laid out raw in the evidence. And what I asked for is not unreasonable, because I cannot expect the Crown to defend me, because the provincial Crown and the federal Crown have both tortured me, and they are involved with the foregoing terrorist activity. So the Crown owes me an obligation to protect its citizens, and since it's involved with the foregoing terrorist activity, it must pay for the legal defense that this terrorism can be prosecuted. Otherwise, this country is a terrorist country. The state of Saskatchewan, province of Saskatchewan, is a state that sponsors terrorism, and that will necessitate the United Nations occupying Canada, because this is in violation of numerous UN conventions. And this is not just a domestic issue. This is an international issue. And any such orders that do not refer this to the Privy Council to go to Parliament is an act of torture and terrorism. And I will be contacting the Office of the Prosecutor to ask for arrest warrants, because this is enough. I've been tortured enough by the Court of Queen's Bench, and I'm tired of people shielding them. I want my remedy for myself, not DSR Terrace Consulting Incorporated. It will seek its own remedy. But I am tired of being tortured. The corporation that I represent is being tortured to destroy my economic security. I've been driven out of my home. Had my daughter taken from me and used as a pawn to torture me. She's being tortured herself because she's being punished unlawfully. She has a right to see her father. I've not laid eyes on my child. You look on page. Let's go to the beginning of this, because I'm not done. Because this is satanic. Let's go to the beginning. I'm going to point this out. I'm not done. This is the last.
I'm going to give you 5 more minutes. We're past that time, so
I'm going to get no. You're going to look at the front of the thing first, and you're going to look at Appendix D. We're going to look at Appendix D, and I'm going to read it. The slideshow that Dale created for the dedication of Karis Kenneth Nicole Richardson to the Lord. He understood the prayer of Hannah as he prayed to God for a child after they lost the first child, and made an oath to God to raise the child in the fear of the Lord if he would answer the prayer to give Dale and Kim a child. The pregnancy was troublesome, but the Lord heard and answered his prayer. Dale purposed in his heart to do what he promised the Lord that he would do, after giving him a gift that he was wholly undeserving of. The name Karis is taken from the Greek word charis, which means grace, divine gift, and the divine influence on the heart. After seeing little Karis fight for life, after she was born 8 weeks early with the cord wrapped around her neck, Dale watched over every moment that he could, looking out for her best interest, and learned that his heavenly Father watched over him the same. Dale chose to give his life in thanks for that gift, and determined to make sure that he lived a life of thankfulness to God and to those around him, no matter the cost. And now the child has been stolen from him. He will pursue her with every lawful means available to him to keep his promise, even if he has to lay down his life to do so. That is what love does. Love sacrifices. Now let's turn the page and look at this, where the journey begins on the next page.
Mr. Richardson?
No, I'm not done.
No, you are done. I'm not giving you any more time. I'm going to hear from Ms. Michael John now. I've given you ample time. I understand you. Thank you.
I wasn't done.
Michael John?
Thank you, Millard. My comments will be very brief. I did sort of outline our general position in the brief of law that I have filed. It is, I guess, from our point of view, somewhat of a straightforward family law matter that we were dealing with. It would appear that these applications are an attempt in substitution of the appeal process that is designated by our legislation. Of course, we're opposed to all of the applications as relate to myself, my law firm, my client. There's no proof of criminal activity. There's no authority which would allow you, in my respectful submission, to remove myself from the file. The allegations are denied. In terms of the issues with Justice Suck's decision, those are matters for appeal, and Mr. Richardson has that option before him. In our submission, we can't use these forms of relief in order to sort of run just an appeal of Justice Elson's order. The fact of the matter is there's still a family law matter that's not yet concluded, in the sense that, for the largest part, we have interim orders we're dealing with. There's no torture or terrorism in this case as defined by. Do you have
evidence of that, Ms. Nickel-John?
These are my submissions. Subject to any questions you may have, my lord, really that's all I have to say.
Thank you.
I would like to see where Mrs. Micklejohn's evidence, because I fail to see any, because provided a pile of it, and without evidence to substantiate it. And I would also like to add that she cannot represent the Court of Queen's bench without actually being their representative. She cannot ask for anything that is going to benefit the Court of Queen's bench. And she is using this to shield them. And first of all, Elson is the target. And first of all, these two, I still need to speak on the writ of certiorari because I did not get to speak to them.
No, Mr. Richardson, I've given you an hour and 45 minutes.
Yes, to speak on the mandamus and the prohibition. Are you telling me what I argued on?
Thank you.
Are you telling me what I argued on?
My decision. You've given me a lot.
Wait a second. Are you telling me what I argued on today? Are you telling me what I argued on?
You've had ample time, Mr. Richardson.
But they were separate motions.
Thank you.
I'm not done.
I'm reserving my decision.
Okay. May God help your soul.